Floor to this honorable court.
Thank you. Be seated. We have one case on our docket this afternoon, case number 19-850, Seidler versus Marina Bay Resort Condominium Association. Mr. Bell.
May it please the court, Charles Bell for the appellate James Seidler. I'd like to reserve 5 minutes for rebuttal, if I might. The court asked the parties to be prepared to address two questions, the first of which was whether the per se reversible error rule set out regarding an erroneous denial of a request to strike a juror for cause in a criminal trial applies in a civil trial where the juror challenged for cause was nonetheless stricken and didn't actually sit on the jury. And to begin my answer to that question, I'd like to refer a quote from the Second District's decision in the Kochalka case, K-O-C-H-A-L-K-A. It's a case from 2015 that we cited in our initial brief for other points, but also cited yesterday in a notice of supplemental authority to give everyone a notice we were going to argue it today. And there the second DCA said on page 126, errors in jury selection are per se errors. They are not subject to any harmful error analysis and instead require a new trial whenever there is a showing that an error occurred. Now, what is important about the Kochalka case is it is a civil case, not a criminal case. And equally important, under the facts, it arose out of the exact same factual scenario the court set forth in its question at the oral argument notice. In that case, the trial court denied a cause challenge to juror Blake. The defendant used its first peremptory challenge on Mrs. Blake and asked for an additional challenge to strike juror Jones, which was denied, so juror Jones sat on the jury. That's the exact scenario we have here.
Well, it's not though, is it, Mr. Bell? I mean, we have the insight here of your client having exercised peremptory on an alternate who would have been on the jury if what you're asking for would have happened. So isn't that different than the second DCA case?
Well, we don't know that. I say that. We don't know the facts. So there's the Kochalka case. I found 7 other cases, which I'm glad to cite in a second, 4 of which we filed yesterday, 4 were in our rehearing motion. All rose out of the scenario that the court set forth, which is whether the juror challenged for cause actually sat. Your question really goes to the, I guess, what you would try to call the distinguishing factors of this case, in that we have a record of a person striking from the alternate panel, a juror who would have moved up to the main panel had they done that. We don't know if those other 8 cases, and frankly there may be others, I just stopped counting at 8, those apply because the courts didn't do that analysis that this panel did. I recognize that I can't say they did do that analysis in those cases. I just don't know. The facts don't talk about how the peremptories were used with alternates. But the problem, there are 3 problems, I guess I would say, with the panel's decision if we were writing on a clean slate. And the first of those, I point out in the rehearing motion, I think it's really critical. The court's opinion, the panel's opinion assumes that all jurors are equally objectionable. And common sense tells us that's simply not the case. And that's especially not the case when it comes to alternate jurors, which the court, I think, pointed out in its own footnote.
No, and certainly, Mr. Bell, there's a footnote dealing with that, and I think, as Judge Tannenbaum said, the calculus may be somewhat different for alternates than regular jurors. But what we know from this peremptory strike is your client did not want juror 12 on this jury. Because there's no other way to look at it other than that, because we know alternates often sit as jurors.
Well, I would start maybe recharacterize the way you phrase that, because I can sort of give you examples of the way, and I picked a couple dozen juries. I've been on a couple dozen other juries that were picked. I mean, I've helped with probably 50 over my career. The calculus is, in fact, different when it comes to alternates. And one of the ways it's different is when you're starting out with a big panel, you've got to play sort of chess because you don't know who the other side's going to strike, and you might say, well, if we strike this person, they're going to strike this person, and et cetera, et cetera. By the time you get to the alternates, it's usually either or. You get one strike, you know what the other side can do only at most one strike. And so basically what happens oftentimes is you may have juror A and B, one is in the box as the alternate, one is not. And you have to ask yourself, I like them both. They're both fine, but there's something about juror B I like better. So in other words, when you get to the alternates, you often strike an alternate, not because you don't like that alternate, but because you want somebody else maybe more. Now, does that make them objectionable? Well, as compared to the two people you struck at the very end, yes, but not as compared to the person you struck a couple hours ago
But
or
you
a few
would
minutes ago.
agree, Mr. Bell, once stricken, there's no chance of that alternate serving on the jury.
Sure.
I
yeah.
mean, so a decision was made that juror 12 would not sit on this jury.
Exactly.
And whatever calculus goes into that, and I agree. I've selected a lot of juries. I've watched a lot of
Sure.
juries being selected. It may be a little different, but the bottom line, it seems to me, but I'd certainly like to hear you on this, is that a decision was made by your client that juror 12, we don't want juror 12 on this jury. I don't know how you can see it any other way.
Well, we don't want, I would say we don't want juror 12 on this jury as opposed to the juror that, we'd rather have the juror that came into the box as the alternate over juror 12. I agree with that. But the question is, the panel's opinion equates juror 12 with juror 22. In other words, the panel said, well, somebody we didn't like sat in the jury. But it may be somebody that we didn't like, but didn't like nearly as much as we didn't like juror 22. But, so that's part of the problem, is you can't assume everything is equal. The second problem, I think, with the panel's decision, it's one that's subtle but important. And that is that basically you put the trial lawyer in the position in a situation like this where he or she has already made a cause challenge that was denied. They get to the alternates. Now, under this scenario, if this case becomes official in law and this becomes the case that binds Florida courts, Florida trial lawyers, that lawyer then has to make a decision. If I exercise my right to use my strike on my alternate, I am essentially waiving the error on the cause challenge. In other words, by the scenario outlined, trial counsel in this case made the decision to strike juror 12 because at the time, and we still think to this day, it's per se reversible on the cause challenge. So what you're essentially saying is, by exercising his right to that peremptory, for whatever reason, didn't like the tie the person was wearing, didn't like anything like that, whatever reason, he has now waived under the court's reasoning the error with the juror 22 or juror 16, I guess I should say, in this situation. And that can't be the case, that you put the lawyer in the position of not being able to exercise a peremptory, which is allowed to him, because if he does, because if you think of it, that's going to happen every single time. If there's a denied cause challenge and you have a juror sitting close to the box, now if you exercise your peremptory, which you're allowed to do, you've waived that other error.
Well,
That's essentially, I think, what's happened there.
Let's step back for a moment. Let me ask you this. Is it your contention that the jury that sat on your client's trial was not impartial?
I don't know that I don't have a contention about that because we don't get into that issue in this case. So I would not make that contention because we're not dealing with cause challenges. In other words, this is a peremptory challenge.
But we're talking about, I mean, because I'm going to get to another point in a moment, but I want to sort of lay it,
Sure.
get some foundational points out of the way. So I did not read and I don't understand that your position is that your client did not receive a fair trial in front of an impartial jury.
I guess the answer is there's no way to ever know that answer, which is why peremptory challenges exist. In other words.
Well, and I'm going to get to that
Okay.
question in a second, but I mean, that is the purpose of a for-cause challenge. So by definition, the for-cause challenge is to get at jurors that you contend are not impartial, for the most part.
It would be,
And the juror that your client focused on, or that you focused on in the briefing, the target juror that had the issues that presumably maybe was less than impartial.
Sure.
That person did not serve on the jury.
no.
So, my next question is, what is the harm? Let me ask it this way. Do you acknowledge that the question here for us, before your client can get a new trial, there has to be a showing of a miscarriage of justice?
I do acknowledge statutorily that's correct.
Okay. So how do you connect the your client's use of the third peremptory for tactical reasons, which you've just talked about? How do you make that connection to a miscarriage of justice?
Twofold. One is you look at the purpose of peremptories, and second, you look at the case law that is
Sure.
out there throughout the thing.
Address
throughout state.
address the purpose of the peremptory first.
Well, let's talk about, I do want to talk about that, and I think the Busby decision, which I know is in my brief, and you all have probably memorized it by now and getting ready for this argument, discusses that at great detail. It talks about the history of the peremptory challenge. But what Busby does very importantly, and I recognize it's a criminal case, but what it does very importantly is it refuses to differentiate an objectionable juror based upon a for-cause challenge and a peremptory challenge. At page 97 of the opinion, the court actually says the dissent would have us have an actual harm requirement where we have to show that the juror who sat should have been dismissed for cause. And the Supreme Court said, no, we're not going to do that because that is part of the process of obtaining an impartial jury. So there are two ways to get an impartial jury. There's the cause challenge, which is the on the surface. Obviously, we've got to get rid of this juror because this juror is simply on the surface, not partial. But what Florida law has allowed for almost 200 years now, what other states have allowed for longer, the federal government for longer, England for centuries, has allowed to use peremptory challenges as a way to guarantee the impartiality of a jury. So the point of this is we don't know, we can't get in the heads of the jurors, and we don't do that, which is why the Supreme Court in all those cases we've cited, Matarins and all the others, and frankly, the 8 cases that we've talked about, or I can talk about now, in the civil context from other DCAs applying this, have said it is per se reversible, meaning that we will presume a miscarriage of justice. We assume a miscarriage of justice anytime you are not allowed to use your peremptories as you see fit because a cause challenge was denied.
Do you acknowledge that there's not a constitutional right to a peremptory challenge in a criminal case or a civil case?
I do agree with that.
Okay.
I agree with that concept.
Is a creature of statute?
It's a creature of statute. It
Okay.
has been for almost 200 years here, exactly.
And you acknowledge that there is no statute that creates a right for a peremptory challenge in a civil case?
It's by rule under the current
Sure.
the current structure. It's by rule, exactly.
So what is, if you can give us your best argument as to what the source of this substantive right, you mentioned, right to a peremptory challenge. What is the origin or the source of that right now that there's not a statute?
Well, the first, I guess, it's certainly by rule. Where does the rule come from? The rule comes from the fact that there's always been a statute. When the statute was, I think, either repealed or thrown out, the Supreme Court enacted a rule. The rule exists, though, and part of this comes down to we have basically 2 centuries of case law on it. So we have, even though we're dealing with a rule now and a statute before, there is, case law going back decades and decades on this right. And the cases have not distinguished between civil and criminal trials at all. And I think the reason is because there is a constitutional right to an impartial jury, but it's not like there's an impartial jury right only for criminal cases. It exists for both. And what the case law in Florida has basically said for the last, at least 40 years in the cases we've cited in our briefs, I think it goes back further than that, is that the use of peremptory challenges is a tool available to the lawyer and to the party to ensure we get an impartial jury. And I guess what I would say sort of in the big picture response to your questions, which I recognize, is that if the panel believes that its decision is correct, and obviously I can't force you to change your mind about that, I think that the court would have to certify this as an issue of great public importance, given the fact that the Florida Supreme Court cases are so clear that this is per se error. It cannot be considered harmless if a person that I wanted to strike off a jury sat in that jury. So, the court can say, we would prefer this to be the rule, but the Supreme Court let us. And if you don't do that, the only way to get around that, in my estimation, would be to try to find a way to distinguish this case because of the civil versus criminal context. And again, I don't see how the court can do that, given the fact that the impartial jury is a right that inures to both civil and criminal parties. But if you
But you
were to
would-
do that, then I think you'd have to certify conflict with the cases we've cited, because they do in fact hold just the opposite. And I don't think you can factually distinguish this case based upon what Judge Jay said on the issue of striking the alternate, because again, we don't know what happened to those cases. We don't know the scenario. And frankly, because peremptory challenges are not all equal, and because they have a right to do that, to use the peremptory, they should be able to do it.
Do you think
And finally, I would say that we have a bright line. Did I interrupt you? I'm sorry if I did. I'm
No, I
sorry.
just, one question before, because we're getting close to
Sure.
your 5 minutes. Do you think the Supreme Court has the power to create a substantive right, like a right to a peremptory challenge by rule?
I mean, I think they create substantive law all the time, and substantive rights. I think they can interpret. I don't think that we're dealing with I think the right exists to an impartial jury. I think what the peremptory challenge is a tool to ensure that. So I don't think the Supreme Court is creating a right to its peremptory challenge as much as it is saying that in order to effectuate the right to an impartial jury, we're going to allow the parties an equal number of peremptory challenges. So I think in that sense, the answer is yes, but I don't think you have to get there in this case, because I don't
Well,
think that's what they're doing.
Let's say the rule didn't exist, that establishes peremptory challenges in civil trials. And the legislature, which repealed the statute in 1973, let's say the legislature just repealed the statute giving, establishing these peremptory challenges, and
Sure.
there's no rule. Do civil litigants have any less of a right to an impartial jury, and are they deprived of an impartial jury?
They have
without the
no
peremptory?
less of a right to one, but they would have lost one of the major tools available to them to do that.
But that wouldn't have any constitutional implications, though, if the legislature if it was just taken away, right?
I think that's a fair statement, because there's no, constitutional right for that. Obviously, we're dealing with quite the hypothetical, which I understand the court is allowed to ask. And I want to say one more thing before I sit, and that is that the other thing about this rule that exists in the Matarens and also all the civil cases that I've cited, and again, just the four I cited yesterday would be enough to certify conflict, is it is a bright line, simple rule that applies equally to plaintiffs and defendants. And if you look at the cases we cite, it really is a situation, unlike in a criminal case where it's almost always the defendant, obviously, who's dealing with that issue on appeal. It goes both ways. I'm not sure I've ever had a decision come out before where I didn't get more phone calls and emails from people on both sides saying, file a motion for rehearing, which is kind of why I'm here. Because it is an equally applicable rule that does not favor one side or the other. And I think that is the other reason that it's an important rule. At the time of this trial, counsel was operating under the guidelines that the cause challenge, because he did all the things you're supposed to do to preserve it, that he was properly preserved, ready for appeal. He had no way of knowing that by exercising his right to that alternate strike, he would therefore waive that right, because there was no case law that would suggest that at the time. So for that other reason, I would suggest that the court doesn't need to even certify this case or conflict, should just simply withdraw its opinion and reverse the judgment. But if you're going to stick with the opinion and reasoning, we think it has to be taken up by the Supreme Court, either on a certified question or certified conflict. So I'll reserve my last 2 minutes. Thank you.
Thank you, Mr. Bell. Mr. Tinker.
May it please the court, good afternoon. Mark Tinker on behalf of Marina Bay Resort. I'd like to address, I think, there are two terms that have been used quite a bit that I think are important. And one of them is, that has been said a lot and is the subject of the questioning, is that there's a right to peremptory challenges. And there is no right to peremptory challenges. That is one of the questions, obviously, the court asked and counsel conceded. There's no constitutional guarantee to it. It is contained in the civil context, unlike criminal. It is in the rule of procedure. It is the rule that governs jury selection in general and selection for jury trials. And under established law, it's a separation of powers issue. A rule of procedure cannot enact substantive law. In the criminal context, we have a statute that gives a substantive right to jury selection in accordance with the statutes. In the civil context, there is no statute. A rule of procedure can govern the procedure that the judges use while performing jury selection, but it cannot enact a substantive right. And that leads to the second issue is The argument that was raised is, well, this is, in the criminal context, it's per se reversible, and I don't believe that's accurate either. There is no per se reversal that happens for issues in jury selection. That's true even with challenges for cause. If that's actually the entire basis for the preservation requirement that a lot of courts call it the Trotter test or whatever you want to refer to it, is if there's a challenge for cause that is wrongfully denied, so we have a judge making an error, that there is still more that has to happen to preserve it because you have to show that there was harm. You have to show that, well, this objectionable juror that the judge should have gotten rid of sat on my jury because I was unable to strike them. So you have to go through the exhaustion of the peremptories and identifying the additional juror. That's the whole basis for the test, is the second component, that there's an error and did it harm me? So there has to be a harm component with cause challenges. The same is true with peremptories. A lot of times peremptories are referred to as, well, they can be for any reason. That's not exactly accurate. We know, and I believe Busby speaks to this, is you can't say I'm striking that juror, that prospective juror, because they're black. That would not be a permissible use of a peremptory. So it would follow from that, if a person uses all the peremptories and they go through the Trotter test and they want to preserve the issue and they say, I'm harmed because if I had one more peremptory, I would have stricken that last black woman sitting there. That wouldn't establish harm because that would not be a proper use of the peremptory. So we know that there's a harmless error analysis that applies in both contexts, including in peremptories. And that's what this court applied in its opinion, looking at the procedure that occurred, looking at the jurors that Seidler found objectionable, and said—
What do you do, though, with the argument Mr. Bell just made, that this trial lawyer is in a very difficult position, based on our opinion, when they evaluate whether to utilize an alternate strike, and prospectively, that lawyer in a similar circumstance may be reticent about doing that, given the fact that that may be seen as a waiver. How would you respond to Mr. Bell's argument in that regard?
It's a difficult position for the lawyer, and it's one that's virtually impossible to address in this setting because we don't know the reasons that are being applied. We don't know why strikes are being used the way they are. The only thing this court has before it is the record of how strikes were used and the identification of prospective jurors that it would have been used on. So we don't know the reasoning. We don't know if the counsel would have made a different decision knowing that this was going to occur, if it would not have identified that juror as someone that they were going to strike, if it would have identified to the judge, had you given me an extra peremptory, I would have used them in this different order. If something like that, I mean, we can't get into the minds of what trial counsel was doing. The only thing the court has before it are the facts that we know that by the process as it played out, that the objectionable juror was going to end up on the trial court anyway, as part of the 6 jurors. And as counsel conceded, it was, as far as we know, it was not it was an unbiased jury. It was an impartial jury. There are no issues that arose from the jury that was actually selected. So it's getting into, can we get into the minds of trial counsel as he's making these selections, and can we say, well, if they'd known this, he would have used that alternate peremptory differently? I don't think that there's any way to do that on appeal.
Mr. Bell also said, given the state of the law at the time, Matarance, this lawyer did exactly what Matarance said he needed to do, which was voice his objection to the fact that the court didn't grant the for-cause challenge, and then ask for an additional peremptory. And little did that lawyer know that we would find this significant, dealing with the miscarriage of justice. But again, following the algorithm of Matarance, and here we are affirming, is that an issue for us to consider here on rehearing?
No, and I'll say, I said before that I thought there was a 2-step process. I'll make it 3 steps now. Is did the judge make a mistake? If the judge made a mistake, did we preserve it? That's what Matarance says, and that's what your question goes to. Did counsel go through and preserve it? And then number 3, was there harm? That's what this court's decision, what the opinion was based on, looking at the manifest error statute, saying based on what the facts are in the record before us, we know an objectionable juror would have been on that jury anyway. So this, well, I actually have it down, this denial of a challenge for cause, if wrongful, I don't believe that the opinion actually establishes that. It says perhaps. I know, I believe your question earlier kind of said if we assume. So that decision was never actually made if this was a wrongful denial of a cause challenge. But
does that matter to us? I mean, there is, perhaps, one word. Does it matter if we found or not that this was error?
Well, it doesn't if you found that it was a harmless error, then it doesn't matter. It matters a great deal if you found that the judge did not abuse his discretion. If Judge Stone was correct in his decision to deny the cause challenge, then none of this matters as far as if there was no error, there's no reason to assess whether it was harmful or not. So yes, it matters, but no, it doesn't for the basis of the opinion, because the opinion assumes, if we were to assume that it was error, let's just say that it was at best harmless error, was what the opinion is based on. So long answer to a short question, no, it doesn't matter for the opinion, but if you decided the judge didn't make a mistake to begin with, then yes, it would make a big difference, because it would mean that the court should affirm for that reason.
Doesn't the Trotter test in this business about preservation, you know, and the sort of this calculus or this routine that a lawyer has to go through just to preserve the for-cause challenge, doesn't it just make sense in a situation like Townsend, where the number of for-cause challenges or objectionable jurors that would be for cause outnumber the number of peremptories in the first place? You know, and like Townsend, they had, 8 that they wanted to strike for cause, and they could only get to 4, you know, the judge denied them, and they used the peremptories they had to strike what they could, and they didn't get enough peremptories to then get rid of the others, so you had objectionable jurors on the panel, ultimately, which then understandably, you know, that's a contention of error, because you don't, if they're right, then now you don't have an impartial jury. Is there a fair distinction between, you know, what was going on in Townsend and the preservation required there, and sort of the situation here where the objectionable juror did not serve on the jury?
I think that there's a distinction, but I think what Trotter does is actually describes what this court did in its opinion. Is Trotter says if there's an error, the judge has made an error in denying a cause challenge, then a peremptory can be used to cure that error, and if the party has extra peremptories left such that they weren't denied any extra peremptories, then that solved the problem, and it's harmless error. So we get back to the harmlessness again. What this court did is looking at the same situation, saying if there was an error, in order to cure the error, you prevent having an objectionable juror sitting on your jury. You've asked 2 questions here today. The first was there any evidence that there was an actual biased juror on this jury? No, there was not. Was the party denied a peremptory challenge to get subjectively someone that they didn't want on this jury removed? No, they were not, because that person would have moved on to the jury and would not have been strikeable anyway, because they would have been out of their challenges by the time that this, or 12, I believe it was, would have moved on. So what Trotter is describing is, again, it's going to, is there harm? Did you end up with a person? And I wrote the quote down. Mr. Bill stated, if there was a person that I wanted to have stricken that sat, that's my harm. Well, here, a person that they wanted to have stricken would have sat regardless. That is what this court's opinion says. So that's where, the entire Trotter analysis is to prevent, can we cure the harm? Here, it was harmless because the objectionable person would have moved on to the jury anyway.
Well, let's critique our opinion a little bit while we're at it. And does it even matter? Like, does even that analysis matter? Do we even need to get to whether the alternate juror would have, sat, or, you've seen the permutations that we went through. If Mr. Seidler got 3 peremptories, which the rule provides for, and he used 3 peremptories, and for whatever purpose, so, it served at least a purpose. It got the objectionable juror off the panel, and it presumably would save a fair amount of time. You wouldn't have to do a new trial if they otherwise were right, that the juror was not impartial. Where is the harm? I mean, at that point, even if, an objectionable juror that they would have stricken, that they wish they could have stricken, not for cause, but just otherwise, how is that harm? And does the preservation rule anticipate that it actually is harm, like in a civil case?
I think that last word is what changes everything, because and it goes to the questions that this court asked in the oral argument notice, is in a civil case, no, because there is no right to peremptory challenges. That's where I started my argument. If you look at Matarance, they say the harm is that if you're allowed a certain number of peremptories and you're forced to use one that you shouldn't have had to use, you don't get what the statute allows you. Well, in a civil case, there is no such thing as the statute allowing you those peremptory challenges, and as I said, a rule of procedure cannot create a substantive right. So that's the big difference. I know the court asked it in its questions, is that, and when we're talking about the civil context, I believe all of the rules in the cases that we've looked at in Matarance and in Busby, they all look at it and say, because of this, you are denied the right that the statute provides. In a civil case, there is no such thing. So I believe if you are left with what the court looked at its opinion, the harmless error statute, and to say, was there a manifest injustice that occurred here? And I agree with the court's analysis, obviously, that did not occur. And, counsel said that there was an impartial jury that served. They used their peremptories. They ended up with a jury that they would have had somebody that they deemed subjectively objectionable on it anyway. So I don't believe that the court can say there was a manifest injustice that occurred.
Right, but going one step further, though, so let's say let's say there wasn't that alternate juror that would have served anyway, so that and it was just a question of whether, okay, this person for cause should have been stricken for cause. The person that was stricken as a peremptory should have been stricken for cause. So they had, they used a peremptory to cover that. And they were just coming in and arguing straight, like, hey, we get a new trial because we had to use one of our peremptories. And we look at it, do we have to go that extra step and look at whether there was a miscarriage of justice because someone would have served anyway, even if they were given a fourth peremptory?
Well, your question is why I said I think that to call it per se reversible is a misnomer, because your question would ask if they had to use a peremptory on someone that should have been stricken for cause, does that end the inquiry? Should that be it? And if it was per se reversible, that would end the inquiry. But we know it doesn't, because the Supreme Court has told us you have to go through and show harm. You have to show that you exhausted your peremptories because you had to fix the trial judge's error. You have to specifically identify a prospective juror that you would have stricken and show that that person actually sat. So it's going through saying, not only can you do this in a vacuum and say, oh, the trial judge made a mistake, new trial, you have to specifically identify who the juror is that you would have stricken. And if there's no purpose for that requirement, if not so that the court can look at it and say, was it because I wanted to strike the black woman from the jury? The court can look at it and say that wouldn't have been a proper use, that did not cause any harm, and therefore, even if the trial judge made a mistake, it was harmless.
Well, what if their claim was just, I would have stricken that person. I didn't like the color of his tie, to use the example from before, and I want a new trial because that person served on the jury, and if I had the peremptory that I shouldn't have had to use, then that person would have served. And so that's my harm, is that the person that I intuitively, I can't articulate the reason why I don't want this person on my jury, but I just know that I don't want them on that jury, and that's my harm. Is that a cognizable harm in this analysis in a civil case?
I don't believe so, because of the issue that it's not a substantive right. It's not conveyed by statute, and the thing that the statutes do provide is the harmless error analysis to look at if there's a manifest injustice that occurred. We know, based on the jury and based on the concession that it was a proper jury, that no harm occurred. And I mean, we're getting into hypotheticals now of what might have happened, but we also do know on this record that an objectionable person, if we're talking about whether it was the color of the tie or whatever it might have been, we know that person was objectionable to the point where Seidler did not even want them to be an alternate and risk that they might move on to the jury at some point. They wanted juror number 12 gone. So we know that that's an objectionable person, would have ended up on the jury. From there, I don't believe that you can get past the fact that it's not a manifest injustice, that there's no absolute right to the strike or to do an extra strike in order to strike someone because of the color of their tie. I believe that's all the notes that I had, unless the court has any other questions. I'll just yield the rest of my time.
Thank you, Mr. Tinker.
May it please the court, briefly, I think counsel said something very important there when he said that it's impossible to answer one of the questions because we can't get inside the lawyer's mind. And we also can't get inside the juror's mind to determine their partiality, which is why the Supreme Court set this per se reversible rule that we talk about. Obviously, the juror has to serve. It can't be somebody that's like an alternate, doesn't go back in the jury room. The Frazier case from the Fourth DCA discusses that. But in this case, we had a juror that we didn't want on the jury that served. And the Supreme Court in Busby declined to differentiate between cause and peremptory challenges on that basis. They said on page 97, we declined to modify the Trotter standard based upon our determination that the Trotter test is necessary to properly protect the right to trial by an impartial jury accorded to every defendant in this state and to effectuate the statutory scheme granting peremptory challenges. Yes, I recognize that's criminal. Yes, I recognize that's statutory. But what's happened is all four of the other DCAs, and I don't know if this, I could not find a case from this court on this fact pattern, so I confess that I'm dealing with other DCAs here. But there were 8 cases that I found, I'll read them now to you, that all held under the exact same scenario we talked about, that the failure, the fact that a person that you could not strike peremptorily served on the jury is reversible error per se. I'd read the Coachella case, which actually used the word per se, but we have the Pearson case and my motion for rehearing at the 2nd DCA. The 3rd DCA, I found 3 cases. The Rivas case from the authority yesterday, Rodriguez case from the motion for rehearing, the Tizon case from the rehearing motion, the 4th DCA and the Bell case, which we filed yesterday, and the Weinstein case, which we filed in the motion for rehearing, and the 5th DCA and the Gouti case, which we also filed yesterday. All 8 of those cases held that when you have to use a peremptory challenge on somebody that should have been removed for cause, and that and somebody else sits that you don't want to sit in the jury peremptorily, it's reversible error. So for that reason, we ask the court to either withdraw its opinion and reverse for the reasons we stated initially in that brief, or at a minimum to certify conflict or a question of the Supreme Court. Thank you.
Thank you, Mr. Bell.
Thank you.
The court will be adjourned.